So I'm Alysa Hutnik. This is Kristi Wolff. We're the lawyer panel, the scary lawyer panel at the end. And I think the point of our presentation is really to add a legal consideration. There's been so much entrepreneurship and creativity throughout the day on what data can do. And this is that other perspective about what are the rules of the road so that you don't end up being a target of a legal type of issue on these.
So I think everybody knows the feeling of you're trying to get out the door, you're rushing to get to work or to drop the kids off or pick the kids up or what have you, and you reach into your pocket or you check your purse and you realize, oh, I forgot my phone, right? And it's an acute anxiety. And if you're like me, you may go throughout the rest of your day or the rest of the evening feeling a little bit lost, right? I don't have my method of communicating, I don't have my news feed, I don't have my emails, I'm just kind of a non-entity, right? And welcome back to 1985. And the reason we all feel that way is because our phones are not just our communications devices anymore, they are the passport to our lives. They are really a universal remote into everything that we control. And so for purposes of today's discussion, we have developed a hypothetical app that will only magnify the degree to which the phone is the universal remote to your life and probably magnify that feeling of anxiety that you get when you realize you left it sitting on your desk. So meet the My Life app. It is suddenly your keys to your connected home. It can turn on your heat, your air conditioning, your dishwasher, shut off the lights, sound the alarm to the door, what have you. Of course, I've also got it connected to my Apple Watch, tracking my steps, tracking my sleep, probably tracking all sorts of other things that I may not even be aware of. And it helps me with my connected car as well. So there it is. It's my life hub. It's the passport to everything I do.
So thinking of that app and thinking of other types of apps and data-centric type of applications, products, well, with the growth of IoT and with the growth of that big data, what we're seeing is a consumer response. And very specifically, a growing sense of concern over my data being collected and feeling like there is a loss of control over how much and where that data is collected and choices around that. And so with that growth of consumer concern and angst, what we're seeing on the legal side is that's really the motivation for the lawsuits, for the government investigations, that is there a line that has been crossed, and what are those rules around that? You know, interestingly, I think the other chart here, it's sure you've got the obvious examples of we're concerned about the unlawful, the hackers, the people who want to steal my data and use it for bad. But it's not just the bad guys that people are concerned about. There's this growing sense, and we're seeing it in these type of stats, that what about everybody else? What about businesses? What about advertisers, data analytics? All these different ways that data is being collected. And a lot of what we see on the counseling side, there's not transparency. And because there's not transparency and there's the confusion by the consumer of what's the value exchange, the fact that you are collecting my data, but for what purposes, and do I have any control over that? Where there's not a clear value exchange, the concern by the consumer grows. And so with that as a background, with our hypothetical app, what could possibly go wrong? You know, the best of intentions, the best of ideas, what are the potential legal snafus that we're gonna highlight? I don't think we could give this type of example without talking about the news and the latest developments between Apple and the FBI, create a key to get to the data, but I think it highlights there are a lot of third parties. There's the government, and there are many others who will want to go after that big data and use it for some sort of purpose. And so the policy question for businesses is, when you have these third parties coming to you and asking for that data or trying to take that data, how did you anticipate that and what is your position on that? Because these are not kind of decisions that you want to have to make on the fly. And so interesting, you know, Apple took the very privacy as a brand position that when the government said you must create this key and hand over this data, because of the privacy, you know, the market differentiator, they took the stand and said, no, we're going to fight that to the end because privacy as a value proposition is central to our brand.
And Apple is not alone. There are lots of other examples of companies that did what every Silicon Valley company hopes to do. What every company hopes to do is that they innovated. They capitalized on consumer desire for convenience and connectivity, and they created something new, and they made statements about it, about how it was helpful and secure, and then found themselves on the front page of the Wall Street Journal, not for being innovative and creative, but for what they didn't think of in the design process. And a great example of this were the baby monitors that came out a few years ago, that you could connect to your phone and see what baby was up to, but they were not secure. And so there were examples of hackers hacking into the monitor, yelling at the baby, "Wake up, baby, wake up, baby." Or parents hearing through the monitor music playing in the room, but when they walked into the room, the music would stop. Why? Because the hacker could see, oh, mom's in the room. Or the hacker moving the monitor to face not the crib, but some other portion of the room. Highly troubling. Any parent can imagine just how troubling that would be. And there are even more recent examples of innovation that sort of finds itself in the news for undesirable reasons. The most recent of these being the example of the Jeep that was hacked by a couple of programmers from Wired magazine. Let's take a look at this in case you're not familiar.
Do it, kill the engine.
So we're killing the engine right now.
Actually, accelerated.
I turned on my hazard lights, but I was still stuck in the right lane with no shoulder to escape onto.
Guys, I'm stuck on the highway.
What did he say? I don't know, I think he's panicking.
Yeah, no panicking. You killed his engine on the freeway. Those hackers seem like they've played so many video games they've forgotten that cars are actual objects carrying living people.
And the point there is with IoT, and as we can make all of our devices and hubs smarter and more efficient and help us with our lives and be able to do so many more things, for all those really positive purposes, there's also the potential for the other aspects. And in the same way that we've been saying in terms of robots being used and quickly exploited to turn to the bad side, you have to think about that with every type of smart device, because from the legal perspective, those are reasonably things that you can anticipate are going to occur. So how do you protect and design around those types of issues? Getting to your legal obligations.
I think it's very easy when you are working with a business, wherever it is, and particularly if it's outside of Washington, D.C. and all the way across the country, to feel like the regulators and everything that happens in D.C. is so far away. It's geographically far away, and it's 3 hours later. And so it feels like it is a different world. And there are some different pressures here to innovate quickly, beat the competition to market, and come up with the next big thing. But when we think about privacy and data security, it really depends on the kind of data that you are collecting. It may cause you to be of interest to a number of different regulators. And as you can see on the slide, we have alphabet soup, really, of regulators that have already said, we're just as interested in this as companies and consumers are, but they're looking at it obviously from a slightly different point of view. What kind of information are you collecting, and what are you using it for, and does that fall within our jurisdiction? So the centerpiece of our discussion for today really is the FTC, the Federal Trade Commission. But as you can see from the slide there, if you are collecting health information, this may be of interest to the FDA, depending on what your product does. If you are collecting financial information, it could be of interest to the Consumer Financial Protection Bureau. This isn't just owned by one regulator. A lot of them have their fingers in the pie at this point. In addition to that, there are state regulators that are becoming more and more interest, particularly here in California, as well as private litigators and consumer advocacy groups that are taking on these products, testing them to see how do they work, what are they collecting, engaging in data mapping, where is the data going, and then may let you know, oh, here's how your product did. It did well, or we're going to go talk to the Wall Street Journal or the New York Times about how poorly your product did, and then that is the story that can become associated with your brand. So let's talk a little bit about what the FTC has done. We've featured here a couple of the reports that they have written, but let me give you a little bit of context about how we got to this stage. So the FTC is broadly charged with preventing unfair and deceptive practices. And you may think to yourself, I don't really know what that means. And the reason is because it's fairly murky, and it's really still being defined as these technologies evolve. But if you think of deception as a material misrepresentation, either something was expressly stated that was not true, or a piece of information that was material to the decision was not given to you, right? So I didn't know, I would not have done this but for. And then unfairness being harm. I gave my information thinking it was for one purpose, but in fact they were using it for something very different. And consumers were harmed by that. That is a basic unfairness concept. So these are the principles under which the FTC is operating. And a couple of years ago, they did what they call workshops, right? So they held some meetings for the public. They do webcast these meetings. It's not something that they tend to get a large audience for, but this is the agency in listening mode. They'll bring in stakeholders from industry, from university, people who are engaged in thought leaders really on these kinds of topics, and they'll talk. And they did one on health information. They've done financial information and connected home, connected cars, that kind of thing. And then they issue their reports, and then they see, okay, who is complying, who is not complying, and then they start to engage in enforcement. So let's talk a little bit about what were their recommendations from this most recent report on the Internet of Things, the topic, the broad heading really that they use for all of this innovation relative to connectivity.
And I'll just highlight, we see best practices, and that's underlined. And often you see best practices, and that's a nice to have, but not an absolute. One of the earlier panels, we heard about Europe and some of their emerging privacy restrictions that have serious financial penalties. In the US, we take a little more expansive approach so that we've got that unfair and deceptive, flexible language, but there are real consequences when you cross that line. So we don't have that black letter, thou shalt not do X unless you do something very specific, but there's still, you have these best practices, and if you don't meet many of these best practices, that ends up being a legal violation.
Mm-hmm. Good. So a few more pieces of information on this. One of the key points that the FTC made in their report was that they're calling on all companies of all sizes and levels of maturity to engage in a thoughtful process relative to security by design and really security by design and privacy by design as well. So bake it in. These are concepts that are very difficult as we look at the lists that are laid out there to reverse engineer, right? Your product's on the market, data security has not been a consideration to date, and so, okay, how do we kind of put a Band-Aid on it, put a patch on it to fix that once we have a mature product? Very difficult, and the agency recognizes that's going to be very difficult. Notwithstanding, they still expect companies to consider it, but really the best way to do it, as they're saying, best practices, is to think of it when it is in the product concept stage and really bake it into the product top to bottom, in addition, baking it into the company culture. So it's something that we as a company have the processes and practices in place for to ensure that we are really carrying through on what we're promising consumers. The middle box, data minimization, likely sounds like an oxymoron to this audience that is hungry for data of all kinds, for various uses. But this is really what the agency is calling on companies to think about. With greater information, many different types of information, according to the FTC, comes greater responsibility to be transparent with consumers about what's being done with it and what is not being done with it. And they really want to see companies make a business case for how they are collecting and using and storing information. Many people may respond to that and say, well, if it's de-identified or it's aggregated, that probably isn't a problem then, right? How could they care about that? But in fact, they do care about that. They have talked many times about how aggregated data can easily be identified in various ways, or de-identified data can be re-identified with particular person with very little effort, really. So that continues to be a concern. And then finally, notice and choice relative to privacy practices. How visible are your practices to consumers, and do they reflect what you actually do, or was it a cut and paste that was borrowed from a similar website and slapped on there to, try to meet the obligations before the product went to market.
So continuing on with the rules of the road, they've also focused on big data in particular. And so they had the workshop similar to what they had with IoT. They've had now the best practices report that's out there. And the next step that usually comes after that is enforcement. So they're expecting that from coast to coast that there is some mindfulness around these types of recommendations and concerns. And one of the key issues that they're talking about with big data is, yes, you can, but should you? Are you using the data in a way that's unfairly discriminating against certain sectors of the population? Are you using data that's going to run right into some very specific laws, because we do have a few specific laws, if you're using credit information? And that's where they specifically called out, if you de-identify, you take away the name, but you essentially still have a customer list, they consider that still to be a credit report if it's used for particular purposes. So there are a lot of snafus, kind of to the title of the program, in this report that if you're using data for any of these purposes, or you're selling, or you're facilitating it, could raise a risk issue if you're not mindful about those controls. I think this point we mentioned earlier on small companies, big companies, the time is ripe now. This is where the regulators are enforcing. And so we've got a couple statements here by some of the FTC commissioners. Nobody gets a free pass. We've dealt with many investigations with small startups. We've dealt with the beta phase. They have still deemed that not to be too small to set an example as to why and whether your information practices were either raised privacy issues or raised security issues. They are looking at what they call emerging technology, and having these old standard rules on unfair and deception to know whether you've crossed the line. So with that tee up, what are those possible implications? So with our app that collects so much type of information, we've got financial information, we've got health information, we've got information about our home and our thermostat and our habits. Clearly, with each bucket of sensitive data, that's going to raise the privacy implications. That's going to make it a more attractive target. It's also more valuable data, so that ups the pros and cons as to what we're collecting and why. The volume of it is going to increase the potential risk factor, and whether we have any kind of smart retention policy. If you get investigated, one of the first questions in the FTC subpoena is, what's your business case for this? Why are you collecting this specific highly sensitive identifier? And do you have a disposal plan for this data? How would you do that? So those are the questions. Do you have certain sensitive pots of information here? Do you have credit information? Even if we see many vendors who say, and we absolutely do not have credit information, without taking a look at that very specific provisions in the statute that create this monstrous, really broad and flexible definition of what constitutes a credit report or a risk score. And I think many companies are surprised when the actual product that they're selling turns out to be a credit report. We've got the data security implications. This tends to get the most high profile. You have certainly the big data breaches, and that's on the news. Those often instigate an FTC breach investigation. But you've also got the data security products, where that product or that service is collecting a lot of data. We've seen a whole surge of FTC investigations around your security by design. Did you have security thoughtful processes that you applied before you put that product out to market? And so is there a potential for misuse of personal data through what you were selling? Is there a potential for misuse and unauthorized access to your network? Or to the Jeep example, is there an actual possibility of harm? People getting hurt to their unlawful access to their homes, unlawful access to devices that could actually hurt them. You've got the smart insulin pumps, the contacts that can measure your health information. What are the potential real ramifications if there's a security exploit there?
And in addition to that, when you think about your go-to-market strategy, beyond just, okay, we've thought about privacy and data security in the concept phase, there are just plain advertising considerations that come along with this that is equally a concern for the Federal Trade Commission. So thinking about how you're communicating what this product can do to consumers, we talked about unfair and deceptive claims are prohibited. So what does that mean? Well, the FTC would look at the advertising claims from the standpoint of a reasonable person. How would a reasonable person understand this product is tracking my steps or tracking my sleep, or if I play these mind games on my phone, I'm going to get smarter and think better and probably get a promotion or something like this. They require companies to have substantiation for those claims, and what exactly that substantiation is can vary quite a bit depending on what the claims are, but particularly for health claims, it's a pretty robust standard, and we've seen some enforcement on that recently where they required a video game. It was the company was called Carrot Technologies, and they had a video game that would allegedly allow people to help with various learning issues and had been studied quite a bit in the field, but the research did not measure up to what the FTC said was its standard of competent and reliable scientific evidence. And so this is something that, particularly if you are in the field of health claims and looking to talk about how your product can benefit consumer health, you want to be very mindful of what is the FTC requiring companies to do, because more and more we're seeing that what the FTC requires may actually go even further than what that particular field of study would think is a typical practice. Sounds a little bit at odds, but it's happening more and more. And then finally, the context of any advertising claim matters. What I might say to one group of people may be particularly reasonable, but then if I change the context just a little bit, it can mean something totally different. It may be conveying very different messages, and that can be highly problematic when we think about what does the advertising really mean to consumers.
And they're looking at claims not just in your traditional advertising, but this is in your sales presentations to potentially other business audiences who are going to purchase your product. They look at your privacy policy that you have on your website. They look at the user guide. They will look at every single one of those types of documentation, your press releases, to see whether the statements you make there measure up with what the actual practices are.
So in thinking about the benefits of connectivity and how these different technologies are being used, and as Alysa mentioned, the value proposition of consumers giving up information but being concerned they're not getting anything for it, what are we seeing in the advertising world that actually seems to be attractive to consumers? And it's this kind of promotion. This is a real promotion by John Hancock Life Insurance Company, where they have essentially said, if you agree to give us your Fitbit data or your activity tracker data, we will give you up to a 15% discount on your life insurance, right? So consumers trading some very personal and persistent information about what they're doing, how active they are, sleep patterns and stuff like this, much of which can affect your longevity, in exchange for paying a little bit less for their life insurance. But because the company is being transparent about what they're doing with that data, even though this is a risk that the FTC said could be concerning to them, the use of this kind of personal data by insurance companies, they're being transparent with consumers, and so consumers are apparently fairly accepting of it because they feel like they're getting something for it, and they feel like they know how the data is being used.
So the other possible implications, that's the carrot approach. Then there's the stick approach, civil penalties. So the FTC, for some of these statutes, can get up to $16,000 per record. It's per violation. And they construe that to be as broad and to add up as big dollars as they can. So that could be per advertisement. It could be per data record in a breach. But if you haven't thought that through, those are the kinds of motivating factors that end up, unfortunately, resulting in settlements or litigation with the agency that put many companies that had really great ideas, really innovative concepts out of business. So to that point, we're at the stage now where there is one division within the FTC that just focuses on privacy and security, and they can't hire enough lawyers fast enough for the cases that they are bringing. Public cases, they've got over 100 privacy and security focused cases. Many of those, as I mentioned before, are focused on small startup type companies out of California, out of Seattle, out of all sorts of places that are not anywhere by DC or New York on the East Coast. The range of practices at issue are all over the map. We have a few examples here, but really get into privacy by design, security by design, whether your statements measured up with your practices, whether you were managing and dealing with highly sensitive data. Is it kid data? Is it credit data? Is it financial data? whether you were doing something that they construed to be sneaky, to be spying, to be in some way unfair to the consumer. And as a result, they launched an investigation. They end up with either you have a choice if the case doesn't close. Do you settle with them and live with a 20-year settlement order that could include provisions such as personal liability for the company owner? Or do you litigate? Do you use all your resources to fight against the government, who has, to some extent, unlimited resources to fight these issues? The FTC is, we've got the privacy and security very active, and then even drilling down into IoT. Their first case was the baby monitor case, one of the ones we mentioned as the snafu type scenario. They looked at, the easy claims are, how was this marketed? They just focused on the word secure. It was used a few times in the materials, and they said, look, it's out there, the camera's out there, it's not secure, the bloggers are talking about it, looking at what did the company do, how did you respond? To Kristi's earlier point, security by design with a camera where the whole nature of it is not super secure is hard to fix at the end stage. It's really an earlier stage type of thing. So the FTC spins that as, you were not responsive to this vulnerability. That's an unfair type of practice. The Asus routers is a more recent example where the company was selling routers and a cloud solution for homes, and they looked at the default settings. When a consumer gets this, how are they going to set it up? And what they said is those default settings were insecure. They were lax. So just because they have the ability to be set up in a more secure manner, there was no education to the consumer. In fact, the settings, that became the unfair practice, and the claims around the products being secure and promising some level of security was considered to be deceptive. At the end of the day, you now have two settlements that, one, put the company out of business, and the other one is a 20-year settlement that's going to apply not just to that product, but to many others, which ends up being a competitive disadvantage when you're going against others who don't have those similar types of controls around them. So how do we get into best practices? How do we not become the target of that next type of investigation?
So one of the first things you want to do when you're conceptualizing what's our product going to be is think about, well, what are we going to say about it? How are we going to sell it, right? It is, at the end of the day, about making money. And it's very important for companies to think very close to the start of the product, what are we going to say about it, and to make sure that those claims are substantiated. I've used here a few examples. They happen to be health claims, but it's important for really any type of product. And as you evaluate your go-to-market strategy and the product gets updated, the next version comes out, it is the advertiser's obligation to make sure that their substantiation remains current and that whatever claims they have in the market are continuously substantiated. It's not enough just to do it one time and then it's out there forever and it's never paid attention to again. It is a continuing obligation as long as the product is being advertised.
And so that's been one of the snafus, not the intentional, but the original version of the claims around the product accurate. But as you start working with different business partners and you start adding different analytics, sometimes there's new types of data collection. Sometimes those new types of data collection with your third parties are not consistent with what you've said with the privacy policy that you have to have. Somebody wrote that. It's posted in iTunes and on your privacy policy on your app. It ends up being there's a disconnect there. I mean, that's often one of those, again, it's the whole life cycle around the product that you need to be concerned about the claims and promises you're making about the product. Privacy and security from the start. If there's a drumbeat that's happening throughout this presentation, those would be the key terms. Because if you do get investigated, when they send you the subpoena, one of the things you need to do is not just, they won't take your word for it. They're looking for your documentation. They're looking for your culture, for your training. What were the risk assessments? Where's the data mapping? Did you analyze the kind of data that you would collect? And what were the security controls around that? They are not looking for perfect security. They are not even looking for perfect privacy. They are looking for a mindful approach. We've gotten many of these investigations closed without any further action if there was that pro-privacy concept. There was good faith efforts in trying to design around these type of considerations and being transparent with the consumer. That goes a long, long way. Transparency and consumer choice. We get into a point where there's so many options. These are the hub, the central hub, our IoT that's going to be our passport to so many things. How do we create the choices to the user in a way they are going to understand? Back to that earlier slide at the very beginning about that consumer angst and people feeling like they don't have control over their data. And you can say, but I've got a privacy policy. I have a user guide that's 45 pages. Of course, I am providing choices. If we don't provide choices that are in a way that somebody can understand and actually use, then often the claim is you haven't provided a meaningful choice. So it's an analysis as to what are we collecting, and is there going to be, I think the plain language way of looking at it is there going to be a negative surprise? If a consumer were to know what kind of data we're collecting from them, are they going to think it's sneaky? Are they going to not be happy with, or not even be accepting? The value exchange is not clear to them. Because if that's the case, you think about if our data practices were on the front page of the Wall Street Journal and what the spin story would be like, are we going to be able to defend that? Were we transparent in various ways in our communications with our users? That's the type of story kind of outside the lab that you would have to defend. And it starts with, are we transparent and do we give meaningful choices around the data use and collection, including how that evolves over time? Third parties. I will highlight this and underscore because you can do what you can do as to your processes, but this is an ecosystem. This is not about a company usually acting by itself. Whether you are a platform, whether you are a service provider, whether you are selling analytics and you're going to help other companies harness their data. The point is, if there are privacy or security violations, if that data is not being used properly, what the FTC does, and many of the other regulators, they look at who has the most leverage here. Who has the position where they really have more information and they have more control. And even if you're not the one, they have this lovely little concept called third-party liability. Did you know or should you have known? Think about the old criminal law, aiding and abetting. Did I facilitate? And they don't accept the, I knew nothing, my head is in the sand, I was not aware. They consider the privacy and security responsibilities for each entity and what amount of that should you have contributed, should you have played a role in. That ends up being a really key factor there. And so having that kind of defense, what's the proactive approach there? What's your due diligence? What's your mindfulness? Are you just taking does the compliance question ever even come up? How is this really neat use of data or analytics? How does this comply with privacy and security laws? And pushing them for some answers as opposed to relying on, to the extent that there's any kind of contract or terms of use, some sort of general statement that, oh, I'm in compliance with all applicable laws. That does not pass muster in a consumer protection in an enforcement realm. That's really a nice comfort adding, where do we shift liability and indemnity? That's great in the contract sense. It's not all that helpful in these types of investigations. So managing when you are collecting data, who are your partners? And where are the privacy and security responsibilities allocated? And is that fairly balanced given who has controls, who has the information, who's profiting? So with that, we are happy to answer questions. I know it's the end of the day, and there's a lot of fun things that are not panel related after this. Around if anybody wants to ask questions after, not under the bright lights. Thank you very much.